This video was created and brought to you by ManageMax. We manage condominiums, HOAs, manufactured housing and apartment communities throughout Southeast Michigan. We're a growing company, and maybe we'll get to your area soon if we're not there yet. We create these videos to share industry insights with current and prospective clients. There will be an opportunity to connect with us at the end, so stick around to the end of the video. Now let's dive in. Today we're going to do a little legal education for those of you who are interested. This one's interesting. A county in Michigan tried to sell 20 condominium units, and the problem was those units no longer existed. They had legally vanished years earlier and nobody even knew. And this is not a hypothetical. It is a real case that went through the Michigan Court of Appeals, and it reveals a risk that most condo and HOA boards have never even considered. Now here's what happened. Oakland County, which is a county in Michigan for those of you that are not in this area, was settling a lawsuit with a developer, and as part of the settlement they agreed to convey 20 vacant condominium units, land that had been platted for development but never built. The settlement included standard as-is without warranty language. The county thought they were protected. The buyer thought they were getting 20 buildable lots. Years later, the buyer discovered the truth. Those units had legally ceased to exist. Under Michigan law, if a developer doesn't complete construction of a condominium unit within 10 years, those undeveloped portions automatically revert to the association's common elements. No filing required. No announcement. It just happens by operation of law. The county didn't know. The buyer didn't know. Nobody checked. And the Michigan Court of Appeals ruled you can't sell what doesn't exist. As-is clauses protect sellers from condition issues, not from conveying property that's legally vanished. This isn't a theoretical risk. It happened in Michigan recently. Here's why this matters to you. When's the last time your board actually verified what your association owns? If your community was developed in phases, do you know whether all the phases were completed or whether some future development areas have quietly reverted to common elements? If there are undeveloped parcels on your original plat, do you know their current legal status? Have developer rights expired without anyone noticing? Most boards inherit their governing documents and assume everything's accurate. The master deed says what it says, the plat shows what it shows. Nobody questions it. But laws change. Deadlines pass, property status can shift automatically without any filing, without any notice, without anyone in your association being aware. What your documents say and what's legally true today might not be the same thing. You might think this only matters to developers buying and selling land. It doesn't. If land has reverted to common elements without anyone realizing it, your association may now own property you're not maintaining, property you're not insuring, property you're not budgeting for. That's a liability sitting there waiting to surface. If your board ever wants to sell or develop that land, or if a future buyer or developer approaches you, you might discover you don't actually have what you thought. Or you might discover you have more than you thought, and the obligations that come with it. If you're in any kind of dispute with a developer over unfinished amenities, maintenance responsibilities, anything, are you certain you know what rights they still have, or have those rights expired without anyone checking? These aren't questions boards typically ask, but they're questions that can cost hundreds of thousands of dollars when the answers come out wrong. This court case is a warning shot. It reveals a category of risk most boards have never considered: the gap between what you assume you own and what you legally own. Verifying your association's actual property status, master deed, amendments, developer rights, expired timelines isn't something you do with a quick document review. It requires expertise in condominium law and property records. It requires knowing what to look for and what questions to ask. If your community has undeveloped phases, unclear boundaries, or governing documents you've never had professionally reviewed or haven't had professionally reviewed in a while, this is a conversation worth having before it becomes a crisis you can't unwind. If you found this perspective valuable, we invite you to connect with us. Facebook viewers, like our page and follow us for regular updates. Feel free to message us directly with your questions or community challenges. Instagram viewers, hit follow and feel free to DM us with your questions or community challenges. YouTube viewers, subscribe to our channel and check out the video description for helpful links. Visit our website to discover our thought leadership content, books, and resources that can transform your community management approach. Whether you're dealing with the challenges we discussed today or other community issues, we're here to help. Thanks for watching, and we'll see you in the next video.